Good morning and welcome to the August 12th, 2026 meeting of the Texas Commission on Environmental Quality. It is 9:30 a.m. I'm joined by my colleagues, Katarina Gonzalez and Tanya Miller, our General Counsel, Mary Smith, and our Interim Public Interest Counsel, David Timberger. For each item that argument or discussion is allowed, we'll inform parties and the public of time limits for their discussion. Registration closed at 9:30, but if you'd like to address the commission on an item, please visit our registration desk, or if you're online, if you're on the webinar, email agenda at tceq.texas.gov with your name, affiliation, and the item you'd like to comment on, and we will do our absolute best to accommodate the request. For those making presentations, please wait to begin your presentation until I have asked you to begin speaking, and please check to make sure that your line is unmuted before proceeding. Before we get started today on the agenda, we have a number of retirements that are going to be really, really rough to announce, but we are so happy for our TCEQ staff. So I think the three of us are going to come up and present to our icons. All right, this first one was a long time coming, but I've been in denial since the day I've got here. Carrie Michelle, our beloved Carrie Michelle, the queen legend icon of water, is retiring. She's been with the agency for over 21 years. That means if she had a kid right when she started, that kid would be drinking by now. She began her current role as director of the Office Water in 2022. Prior to becoming the director, she held several positions in the agency, including assistant and deputy director of the Water Supply Division, where she developed a keen interest in water issues, I would say so. Carrie Michelle started her career at TCEQ as an enforcement coordinator and a team leader in the Office of Compliance and Enforcement, and served as a special assistant to deputy director of the Enforcement Division in the Office of Waste Radioactive Materials Division. Wow, I didn't know you did all of that.
Good.
Jeez. Before joining the agency in 2005, Carrie Michelle taught biology courses at the University of Mary Hardin-Baylor. Of course you did. She also worked as a researcher for the Agricultural Research Service in the USDA and was employed with the City of Austin Fire Department. Amazing. Most interesting woman. But beyond that, she has been the biggest cheerleader for all the staff at TCEQ. And when I first started at the Water Development Board, it was like an infant to water policy, she sat down with me and talked to me about TCEQ's role and TWD's role and how we could work together. And it was the most impactful meeting I had that first year, and really drove home the importance of water to me and made that my top priority moving forward. And she's shaped and molded so many people here, and no one is more entitled to this incredible retirement than Carrie Michelle. I hope she'll be back in 6 months, but I think she's actually really retiring, which is well-deserved. So let's give Carrie Michelle a round.
Yeah. In the middle, be careful.
Yeah.
All right, that's perfect. All right. 3, 2, 1. Perfect. One more. 3, 2, 1. Perfect. Thanks.
Now get out of here. Just kidding. Oh, I know, seriously. All right. Well, this is another doozy of a retirement. Beth Seaton, our director of the Office of Waste, another queen legend icon. This one hurts. Beth is the director of our Office of Waste, which includes Waste Permits Division, Remediation Division, Radioactive Materials Division, and the Occupational License and Registration Division. She has been at the agency for 27 years and worked in numerous programs and roles. She started her career as a project manager in the Remediation Division in 1999. From 2000 to 2009, Beth worked in numerous capacities within water and wastewater programs, including outreach, permit writers, technical specialist, team leader, special assistance to the director, and assistance division director. From 2009 to 2011, Beth worked in the Office of Compliance and Enforcement as a special assistant, working on various office issues. She served as the Deputy Director of Remediation Division from 2011 to 2023 before moving to her current role in Office of Waste. Beth has a Bachelor of Science in Biology and Physical Science and a Master of Science in Environmental Analysis and Management from Troy University. That's a lot. That resume, it's a big resume. But what this doesn't say is that Beth is the kindest and greatest manager. Her team loves her. She leads with kindness and intelligence, and that is going to be very hard to replace. But she's built a great team, and they are fully capable of moving into her very hard shoes to fill, but she's done that on purpose. Her people love her, and they are ready to go, and I can't thank her enough for that. This was another one that hurts, and I still hope that we see her back in 6 months, but again, not sure that's happening. So let's give a round of applause to our Queen of Waste. I hate that, but Queen of Waste. Yeah.
Perfect, careful. Perfect. All right, looks great. There you go. All right, 3, 2, 1. Maybe one more. 3, 2, 1. Cool. Thanks.
When the staff told me we were going to have all these retirements this morning, I was like, what the heck? This one?
Yeah, that one's live.
Okay, great. It's hard to lose so many good people. You can hear from the bios here just how dedicated this group has been to the agency. To me, I'm so happy for them. I mean, I would prefer to keep them. And as I tell everyone that retires, you can always come back, right? But it feels like we owe them a lot more. That the state of Texas owes them a great deal of gratitude for all their years of service. So thanks, y'all. But next we have Todd Gallagher. You here? Todd Gallagher? Okay. So Todd began his career with the state of Texas in 1990 at the Texas Comptroller's Office. There he was part of the team that developed the USAS accounting system. After 2 years, he left to attend South Texas College of Law, and upon graduating in 1995, he joined OPIC, where he remained until 2001, when he came to his senses and made the move to OLS. No offense, OPIC. Todd started out as a staff attorney handling municipal solid waste and utility rate CCN cases. In 2006, he was hired as a senior attorney for the water rights and water utilities section. When the utilities section transferred to the PUC in 2014, Todd chose to remain at TCEQ. Thank you, Todd. In 2015, the water quality senior attorney resigned, and the water quality section merged with Todd's section, creating the water section, which was comprised of water quality, water rights, public drinking water, and districts. This was an enormous undertaking, and Todd definitely took the helm, leading the section until 2025, when water quality once again became its own section, allowing Todd to devote himself fully to his true love, water rights, public drinking water, and of course districts. Todd is described by his colleagues as the epitome of calm under pressure. We know he's seen a lot over the past 30 years, but he's never once lost his cool. His staff attorneys say he's the kind of leader all leaders should aspire to be: patient, fair, and inspiring. He has a true open door policy, and his attorneys know they can always count on him, whether they need to discuss a difficult case, work through a legal argument, or simply talk about life. And don't let Todd's quiet demeanor fool you. He's funny, sharp, and always has a signful quote ready to go. Todd's a good listener. He's consistent. He's generous in giving credit. He teaches without being patronizing. He leads without being arrogant, and he serves without seeking recognition. Most importantly, Todd is one of the kindest people you'll ever meet, and we were all fortunate to have had the opportunity to work with him. Next, we have, I did it again, Kelly Mills, the Deputy Director of the Water Quality Planning Division. Kelly has been with TCEQ since 1993 and has served as the Deputy Director of the Water Quality Planning Division since 2023. The division preserves and improves the quality of the state's surface waters by establishing quality standards, monitoring, assessing, and reporting conditions, and implementing plans to reduce pollution and improve water quality. The division works in close cooperation with other divisions and the Office of Water to implement the standards through permits, update the water quality management plan, and assess the quality of source waters for public water supply. Kelly served from 2015 to 2023 as the Assistant Deputy Director of the Water Availability Division. In this role, he supported water rights permitting and wastewater programs and facilitated groundwater protection activities as the designated chairman of the Texas Groundwater Protection Committee. For a 13-month period in 2021 and 2022, Kelly represented the Office of Water on the TCEQ Sunset Review Team, a huge undertaking, as I recall. During this time frame, SRT prepared the agency's 2021 self-evaluation report and facilitated meetings, site visits, and information exchange between the agency's program areas and the Sunset Advisory Commission staff. From 2007 to 2015, Kelly served as the leader of the Water Availability Division groundwater team and was a member of the team for the rest of his prior service at the agency. This team has responsibilities to facilitate and administer the Texas Groundwater Protection Committee, conduct groundwater conservation district performance review, and implement the Priority Groundwater Management Area Program. Kelly received a Bachelor of Science in Geoscience Geology from Texas Tech University in 1985. He is a licensed Texas professional geoscientist. Thank you, Kelly.
Okay, and last but certainly not least, Bill Shafford. I can't say nice things about you till you come up here. Bill Shafford is a registered professional engineer in the state of Texas. He received his Bachelor of Science in Chemical Engineering from the University of Texas at Austin in May of 1987. After working in consulting for a couple of years, Bill started employment with the Texas Water Commission, later TCEQ, in December of 1990, and has worked diligently serving the state of Texas for over 35 years. That's a big mile. Congrats. His work at the agency has included hazardous waste, permitting, remediation, and technical assistance across waste programs. Bill is currently the technical specialist for the Office of Waste, dealing with various issues across the office. These tasks include providing technical assistance to the director and to the divisions, assisting with legislative implementation, rulemaking, and other agency initiatives, including the above-ground storage vessel safety program and produced water issues. Bill has also acted as a liaison between the TCEQ and several national technical and regulatory organizations focusing on waste issues. And I would just like to add that when I first started at TCEQ and came down to the radioactive materials division in the Office of Waste, Bill was working in the Office of Waste at that time, and it was a tremendous help. This is a powerhouse of knowledge for this agency, and we'll be sad to see you go, but congratulations. Thank you.
Thanks, Sean.
All right, bittersweet beginning to this agenda. We love all of our staff at TCEQ, and they are the greatest public servants that Texas has for the environment. I'm just so proud to be chairwoman, and I know fellow commissioners here feel the same. So with that, let's go to item number 1.
Item number 1 is the consideration of the ALJ's proposal for decision and proposed order concerning the application by U.S. Ecology Winnie, LLC, for renewal and amendment of permit numbers WDW 344, 345, 346, 347, 348, 349, and 350. The order of presentation will begin with the applicant, followed by the protestants, the ED, and OPIC in that order. The parties have been notified that they will have 5 minutes each of oral argument time. The applicant may save time for rebuttal as it bears the burden of proof on the application. And with that, we'll invite the applicant to come to the front.
Okay, is this working? Yes.
Good morning.
Are you ready for me?
Yes.
Good morning, Commissioners, General Counsel. My name is Maddie Nader, and I represent U.S. Ecology, which seeks the renewal and amendment of 7 currently permitted Class 1 non-hazardous underground injection control wells. I note that this is at a facility that's been in operation for over 25 years and has a perfect compliance history. This case presents a singular narrow issue, whether U.S. Ecology's injection will impair any existing rights under Texas Water Code Section 27.051A2. The ALJs considered that issue, found that no existing rights would be impaired, and recommended issuance of the permits. The Pipkins's primary argument against that is that migration of U.S. Ecology's inject date will impair some vague and undefined right to develop business, but that is not the standard established under Texas law. The Texas courts have already addressed this precise referred issue in an administrative appeal of a TCEQ UIC permitting matter. In that case, FPL Farming, the court interpreted the statute before you today and determined that migration alone does not constitute impairment. Rather, it must be accompanied by some measure of harm. The Pipkins' only argument in response to FPL is the case of Myers-Woodward. They argue that that alters the FPL standard. That is not correct. Myers-Woodward is a case about a contract dispute which does not involve TCEQ, permitting, or even injection wells, nor does it alter the law, which has long held that property owners own what is beneath their property. With that argument, the Pipkins asked the Commission to adopt a different standard, that migration itself is impairment. But that is not the established standard, and the ALJs correctly applied the standard here today. First, the Pipkins did not even establish that U.S. Ecology's waste would migrate beneath their property. Their sole expert relied on a conservative worst-case scenario model in the application and it treated the plume model as a prediction of where actual future migration would occur. But the record clearly shows that that conservative model was developed as a conservative screening tool to evaluate potential impacts to underground underground drinking water, not as a prediction of where injectate will actually migrate. The Pipkins did not do any independent modeling to show where injectate may actually migrate. Second, even if we assume that some migration may occur, the Pipkins still failed to identify any way that they would be harmed under the FPL standard. The only theoretical use that the Pipkins presented, the only potential use that the Pipkins presented was a future carbon sequestration project with Chevron. However, the record shows that Chevron has not applied for a permit, nor have they even established whether the property is suitable for carbon sequestration. In fact, the record shows that it is not, for reasons having nothing to do with U.S. Ecology's application. The Pipkins did not identify any other use for their pore space. So after all the evidence is considered, the Pipkins' impairment argument ultimately rests on the possibility of migration alone. Mr. Pipkin himself stated, and I quote, "Just the fact that it, being U.S. Ecology's injectate, is on the Pipkin property is the issue." But FPL farming already addressed that argument. Migration alone is not impairment. To the extent that the Pipkins seek to establish trespass or other property right questions arising from any alleged migration, those issues are being addressed separately, but they will be addressed in pending civil litigation. The only question before the Commission today is the specific narrow statutory question under Section 27.051A2 of the Water Code. For those reasons, the evidence establishes that the application complies with the UIC regulations and will not impair any existing rights. U.S. Ecology therefore respectfully requests that the Commission adopt the ALJ's PFD and grant the permits. I'm available for any questions and would like to reserve any time for rebuttal. Thank you.
Thank you very much. We'll hear from the protestants now.
So no one registered for the protestants, but we can I'll check with the chief clerk and just confirm that there's no one online too. Okay, there's no one online for the protestants for this item.
All right, we will move on to the ED.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. My name is Thomas Hopkins, and I'm a staff attorney in the Environmental Law Division, Waste Section. With me today is Pranjal Mehta, Senior Attorney for the Waste Section, and we are representing the ED in this matter. In general, the ED agrees with the ALJ's proposal for decision and proposed order, subject to the clarifying revisions proposed by the ED and subsequently incorporated by the ALJ's in the exception letter. However, while reviewing the materials for this agenda item, we also found that the PFD in finding of fact number 9 in the ALJ's proposed order refers to changes in the injection intervals, while the draft permits address only changes to the injection zone and do not propose any changes in the injection intervals. We want to bring that correction to your attention for clarity. The draft permits would authorize continued operation of the Class 1 injection wells for non-hazardous industrial and municipal waste with revised technical requirements, but would not increase the total authorized injection volume. Turning to the referred issue, whether issuance of the draft permits would impair any existing rights under Texas Water Code Section 27051A2. After considering the entire evidentiary record, including the prima facie demonstration, the expert testimony, and the parties' arguments, the ALJs concluded that the record does not show impairment of any existing rights under the Texas Water Code. The ED respectfully requests the Commission adopt the ALJ's proposal for decision and revised order, incorporate the ED's requested revisions, and issue the draft permits as prepared by the ED. Thank you, and we're available for questions.
Thank you very much. We'll hear from OPIC now.
Good morning, Chairwoman Vaught, Commissioner Gonzalez, Commissioner Miller, General Counsel Smith, and Executive Directors, Attorneys. My name is Eli Martinez on behalf of the Office of Public Interest Counsel for the record. After careful review of the proposal for decision, the exceptions filed by the Pipkins, the applicant's reply, the evidentiary record developed at the contested case hearing, OPIC recommends that the Commission adopt the administrative law judge's proposal for decision and grant the draft permits as recommended. The single issue referred by the Commission is whether any existing rights, including mineral rights, will be impaired by the proposed injection activities under Texas Water Code Section 27.051A2. The ALJs correctly concluded that the Pipkins established an existing property interest in the pore space beneath their property. OPIC agrees with that finding, as its conclusion is consistent with the Texas Supreme Court's decision in Myers-Woodward. However, the dispositive question is impairment of that interest. Under the controlling precedent of FPL Farming Limited versus Natural Resources Conservation Commission, migration of injectate alone is not sufficient. The Austin Court of Appeals held that some measure of harm must accompany the migration for there to be impairment under Section 27.051A2. On this record, that measure of harm has not been demonstrated. The waste plume model calculations in the application are a conservative, worst-case screening tool designed to protect underground sources of drinking water. They intentionally incorporate assumptions that overestimate lateral extent. They are not a prediction of actual present or future location of waste under normal operating conditions. Even the limited alternative modeling offered by the applicant shows at most a de minimis excursion under highly conservative assumptions. The Pipkins' asserted commercial use of the pore space for carbon sequestration remains speculative. The record shows only an option-type agreement with Chevron that requires future site suitability determinations. No sequestration is currently occurring. Even if the option is commercially viable and exercised, expert testimony further indicates that the relevant injection zone or interval utilized by U.S. Ecology is not suitable for carbon dioxide storage, and any feasible sequestration project would require a deeper confining zone not in communication with the permitted injection interval. In short, the evidence does not establish a significant intrusion under normal operating conditions, nor does it establish interference with any currently existing or sufficiently definite economically beneficial use of the pore space. Because the record does not demonstrate the measure of harm required by FPL Farming, applicant has carried its burden under Texas Water Code 27.051A2. The draft permit satisfies the statutory record, and OPIC therefore respectfully recommends that the Commission adopt the proposal for decision and issue the renewed and amended permits as proposed by the Executive Director and recommended by the Administrative Law Judges. Thank you. I'm available for any questions.
Thank you, Eli. I do have one question. Eli and David, are you okay with revising as the Executive Director noted?
I have no objection to the injection interval being revised to the injection zone and finding of fact number 9.
Thank you. Appreciate it. Applicant, you have You have 58 seconds.
Okay. I don't think I need that time, but I think I would note that we agree with everything that both the Executive Director and the Office of Public Interest Counsel noted. They highlighted a couple of additional facts that are pertinent, and we would respectfully request that the Commission grant the permits, and the revision that the ED recommends is okay with the applicant as well.
Okay,
Thank you.
thank you. All right, doing a little work on the fly here. For item number 1, we're considering the application by U.S. Ecology LLC for the renewal and amendment of 7 Class 1 underground injection control permits in Jefferson County. I agree with the ALJ's recommendation that the permits will not impair the protestants' existing rights in accordance with Texas Water Code Section 27.051A2. I would adopt the ALJ's proposed order with the recommended changes in the ALJ's June 15th, 2026 letter responding to the exceptions. I would also make 2 additional changes to the proposed order to clarify that the Commission is finding that the application satisfies the statutory requirements of the Texas Water Code Section 27.051A. I agree with ALJ's that the permit will not impair the protestants' existing rights and other aspects of the permit were not contested at the hearing. To clarify this in the order, first, I would add a citation to the Texas Water Code Section 27.051A to conclusion of law number 5. And secondly, I would add a conclusion of law stating that the application satisfies the requirements of Texas Water Code 27.051A. I would also adopt the ED's response to comments and issue the draft permits as recommended by the Executive Director. Fellow Commissioners, what are your thoughts?
I'm in agreement.
I'm in agreement. Do we need to add the finding of fact 9 change too? Did you state that one?
Yes,
Okay.
I got it on the motion.
Okay,
Yep.
great.
All right. I move that we adopt the ALJ's proposed order as revised by the ALJ's exceptions letter dated June 15th, 2026 with the following revisions. A, to clarify that the application satisfies the statutory requirements of Texas Water Code Section 27.051A, many aspects of which were uncontested in the hearing. 1, add citation to Texas Water Code Section 27.051A to conclusion of law number 5. And 2, add conclusion of law number 14A, stating that application satisfies the requirements of Texas Water Code Section 27.051A. B, amend the finding of fact number 9 to replace the term injection intervals with the injection zone to accurately reflect the revised technical requirements of the permits. 2, issue the draft permits for renewal with amendment of WTW 344, WTW 345, WTW 346, WDW 347, WDW 348, WDW 349, and WDW 350 as recommended by the Executive Director, and adopt the ED's response to comment. Do I have a second?
Second.
All those in favor say aye.
Aye.
Thank you. Motion passes. We'll move to item 2 once everyone gets settled.
Item number 2 is the consideration and hearing on an application by Tarrant County Freshwater Supply District Number 2 for additional wastewater and drainage powers. The district has requested the approval of additional powers and should present the item, followed by interested persons. Currently, there's no one signed in. The ED and OPIC. Each party may have 5 minutes for oral presentations, and the district may reserve time for rebuttal as it bears the burden of proof on its petition. So that will begin with the district. Nobody is registered for the district, but I don't know if someone is here in the room today, and I can ask the chief clerk if someone has signed in since then.
Is Mr. Harrell here?
No one seems to be online for the district.
All right, we will move to any interested persons.
There was no one who signed in to address the commission.
Edie?
Good morning, Chairwoman, Commissioners, General Counsel, and the Public Interest Council. My name is Elizabeth Cabrera. I'm an attorney with the TCEQ's Environmental Law Division, representing the Executive Director. With me is Justin Tack from the District Section. The Commission received an application from Tarrant County Freshwater Supply District Number 2 requesting the approval of additional powers to provide wastewater and drainage services as provided in the Texas Water Code Section 51.331 and the 30 Texas Administrative Code Section 23915. Based on a review of the application and supporting documents, the district's request to include wastewater and drainage facilities is feasible and practicable, will benefit the land, and will further public welfare. Therefore, the ED requests that the Commission issue an order granting the district's request for additional powers to provide drainage services. Thank you, and we're available for any questions.
Thank you very much. We'll hear from OPIC.
Good morning, Chairwoman, Commissioners, General Counsel, and Executive Directors, attorneys, and staff. For the record, I'm Jessica Anderson on behalf of the Office of Public Interest Counsel. OPIC has reviewed Tarrant County Freshwater Supply District Number 2's request for additional powers to provide wastewater and drainage services in accordance with 30 Texas Administrative Code Section 293.15 and respectfully recommends granting the request. The district's acquisition of wastewater and drainage powers is necessary to serve the proposed development within the district and will benefit the land within its boundaries. The proposed drainage construction should have no adverse impact on land elevation, subsidence, groundwater levels, recharge capacity of groundwater sources, natural runoff rates, or water quality. Additionally, the district has not previously issued bonds and has no outstanding debt. Notice of this hearing, as required by 30 Tax Section 293.15C1, has been satisfied by publication in the Fort Worth Star-Telegram on July 29th and August 5th, 2026. Additionally, a copy of the resolution requesting addition of wastewater and drainage powers was submitted to the City of Fort Worth at the same time it was submitted to TCEQ pursuant to 30 Tax Section 293.15H2. Based on a review of the application and supporting documents, the district's request to have the authority to provide for the purchase, maintenance, and operation of wastewater and drainage facilities for its customers is considered feasible. Thank you, and I'm available for any questions.
Thank you very much. Since Mr. Harrell is not here, there's no need for district rebuttal, and we will move on to commission discussion. Item number 2 involves a request to approve the acquisition of additional wastewater and drainage powers for a district. The commission may grant the application if it finds that it would serve in the best interest of the district and would be a benefit to the land and property included in the district. The statutes provide for the commission to conduct a hearing. This agenda setting satisfies the hearing requirement. The statute also has unique published notice requirements. I'd like to note that as of this morning, the applicant has not filed tier sheets or publication affidavits. However, the ED supplemental filing on Monday did include tier sheets, which arguably could be enough to show substantial compliance with a publication requirement. The applicant also properly submitted a copy of the resolution with the City of Fort Worth. Additionally, the ED's backdated technical review memorandum confirms that the economic feasibility of the request. But before we move forward, I'd like to see where my colleagues are on this item. Katarina.
I'm good with granting the request for approval of additional wastewater and drainage powers.
Commissioner Miller?
I think our rules require that the applicant submit evidence of the published notice by filing copies with our chief clerk, and we allow for them to even show up at this hearing and do that, and they have chosen not to do so, either before or at this hearing. So I would suggest that we postpone this matter to a future agenda. And if I have a colleague in agreement, I will make a motion.
I do. The rules exist for a reason, and the applicant's not even here.
I'm good with postponing as well.
Okay. You ready?
Yep, go for it.
I move that we continue this item to a future agenda to be scheduled by the General Counsel to afford the applicant an opportunity to file the Commission's affidavit of publication and newspaper tear sheets to ensure that the notice of the hearing was properly made.
I second. All those in favor say aye.
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 Thank you. We will move on to number 3.
Item number 3 is the consideration of the adoption of the renewal with amendments of the pesticide general permit number TXG 870000. The executive director's staff is here to present this item.
Good morning.
Good morning, Chairwoman, Commissioners, General Counsel, Public Interest Counsel. On behalf of the Executive Director, I'm Shannon Gibson with the Water Quality Division. With me today is Mari Salazar-Tucci. Can y'all hear me okay? With the Environmental Law Division, and Greg Easley with the Water Quality Division. Staff are here today to request adoption of the amendment with renewal of Texas Pollutant Discharge Elimination System General Permit Number TXG 870000, known as the Pesticide General Permit, which authorizes discharges of biological pesticides or chemical pesticides, including insecticides, nematicides, rodenticides, fungicides, and herbicides that leave a residue in water when such applications are made into or over, including near, waters of the United States. The proposed general permit will replace the existing general permit when it expires on November 2nd, 2026. The draft permit was sent to the United States Environmental Protection Agency for their review on April 6, 2026. On August 20th, 2026, the EPA approved the general permit with no objections. Public notice of the proposed pesticide general permit and public hearing was published in the Texas Register and the Houston Chronicle on March 6, 2026, and a hybrid virtual and in-person public meeting was held at TCEQ on March 17, 2026. The public comment period ended that same day. Staff received comments during the public comment period. However, no changes were made to the general permit or fact sheet in response to those comments. The Executive Director's response to comments was prepared and included in the backup materials before you today. Staff respectfully recommends adoption of this general permit and the Executive Director's response to comments. Staff also requests permission to make non-substantive revisions as necessary to comply with Texas Register requirements. Thank you for your time this morning. We're available for any questions.
Thank you very much. Mary, has anyone signed in on this item?
No one has signed in on this one.
We'll hear from OPIC.
Good morning, Chairwoman, Commissioners, General Counsel, and Executive Directors, attorneys, and staff. Again, for the record, I'm Jessica Anderson on behalf of the Office of Public Interest Counsel. OPIC has reviewed this renewal with amendment of the Pesticides General Permit and respectfully recommends adoption. The draft permit was sent to the United States Environmental Protection Agency for their review, and TCEQ received a no objection letter from EPA with approval to proceed with issuance. There are currently 17 facilities authorized by notice of intent under the existing general permit, and a significant number of additional notices of intent are not anticipated. A letter was sent to facilities currently authorized under the general permit informing them of this renewal and providing allowing an opportunity to submit preliminary comments. Many of the proposed changes from the current permit were included for consistency across Title 30 of the Texas Administrative Code and EPA's Pesticides General Permit. Public notice was published in the Houston Chronicle and the Texas Register. An in-person public meeting was held on February 23, 2026, and a hybrid public meeting was held on March 17, 2026. The status of this permit renewal will be included in the quarterly Water Quality Advisory Workgroup meetings and posted on the TCEQ Water Quality General Permits website. Several public comments were received regarding water quality, monitoring, cumulative impacts, non-numeric limitations, non-chemical alternatives, and pest emergencies. These comments were responded to by agency staff, who explained the scope of this permit renewal and EPA's jurisdiction over certain aspects of pesticide regulation and application under the Federal Insecticide, Fungicide, and Rodenticide Act. This permit action is not expected to create any direct effect on the public, though OPIC would note that members of the public will benefit from greater consistency in the pesticide regulatory regime and the continued regulation of pesticide discharges in proximity to waters of the United States. Thank you, and I'm available for any questions.
Thank you very much. Thank you to staff and thank you, OPIC. As noted, this is a renewal with amendments to the agency's pesticide general permit. As staff have noted, the proposed amendments update language, definitions, references, and make other similar changes to provide clarity, ensure consistency with EPA requirements, Texas Administrative Code sections, and federal legislation. I appreciate the stakeholder inclusion and involvement in this matter, and I note that EPA reviewed the draft permit and supports issuance. Based on my review, I support moving forward with adoption. Colleagues?
I agree. I support adoption, and I really appreciate the staff's work on this item and all the stakeholder outreach.
I'm in agreement.
Do I have a motion?
I move that we adopt the renewal with amendments of Texas Pollutant Discharge Elimination System General Permit Number TXG 870000 as recommended by the Executive Director.
Do I have a second?
I second.
All those in favor say aye.
Aye.
Thank you. The motion passes. Thank y'all. Move on to item number 4.
Item number 4 is the consideration of the implementation plan for 9 TMDLs for indicator bacteria in the Chocolate Bay watershed of the San Jacinto Brazos Coastal Basin and Bays and Estuaries Basin. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Nicole Hall with the Water Quality Planning Division in the Office of Water. With me today is Nicole Reed with the TMDL program and Maricela Zertucci with the Environmental Law Division. Today, the Executive Director is requesting approval of the implementation plan for 9 total maximum daily loads for indicator bacteria in the Chocolate Bay watershed in the San Jacinto Brazos Coastal Basin and Bays and Estuaries Basin. The activities within this implementation plan target 9 assessment units in 7 water bodies within Brazoria, Fort Bend, and Galveston counties. The development of this document included an active public participation effort and balanced stakeholder groups coordinated by TCEQ and the Houston-Galveston Area Council. Stakeholders were tasked with providing input on the implementation plan document. The success of this project is due to the collaborative effort of the individuals and organizations who put in the time to develop the document and improve water quality in their communities. The Executive Director respectfully requests approval of the implementation plan, and permission is also requested to make non-substantive and clerical corrections if needed. Thank you, and we are available to answer any questions.
Thank you very much. Mary, has anyone signed in on this item?
No one is signed in.
Hear from OPIC?
Good morning again, Chairwoman, Commissioners, General Counsel, and Executive Directors, Attorney, and staff. My name is Eli Martinez on behalf of the Office of Public Interest Counsel for the record. OPIC supports approval of the implementation plan for 9 total maximum daily loads for indicator bacteria in the Chocolate Bay watershed. This I-Plan covers assessment units in Brazoria, Fort Bend, and Galveston counties. Its goal is to restore the primary contact recreation one use by reducing fecal indicator bacteria, E. coli in freshwater, and Enterococcus tidal waters to the levels that were established in the adopted TMDLs. This plan is in the public interest for several reasons. First, it protects public health and the designated uses of these waters. Elevated bacteria levels impair swimming and other primary contact recreation. Chocolate Bay itself is also impaired for recreational oyster harvesting. Reducing these loadings protects families, anglers, and communities who rely on these water bodies. Second, the plan is comprehensive and stakeholder-driven. Developed with the Houston-Galveston Area Council and the Chocolate Bay Coordination Committee, it identifies 5 practical management measures that address the dominant sources identified through load analyses and stakeholder input. The first is maintaining and improving wastewater treatment facility and collection system performance, including fats, oils, and grease, education, and SSO, or sanitary sewer overflows reduction. Second, promote proper on-site sewage facility use, inspection, and repair. Third, reduce urban stormwater contributions from pet waste and illegal dumping. Fourth, supporting voluntary land management practices and riparian improvements for livestock operations. And fifth, promoting feral hog management through education and voluntary control measures. These measures target both regulated point sources and the larger non-point sources that drive most of the loading. Thirdly, the plan uses an adaptive management approach. Stakeholders will track measurable milestones, review Clean Rivers program monitoring data, and adjust strategies as needed over the 5-year period. This flexibility, combined with ongoing public communication and reporting, provides reasonable assurance of progress while remaining responsive to local conditions and funding realities. Finally, the I-Plan benefits not only the listed assessment units, but the broader Chocolate Bay system and the upper Gulf Coast waters already covered by the 2015 Bacteria Implementation Plan. Success will be measured through both programmatic milestones, such as workshops held, infrastructure improvements completed, and voluntary practices adopted, and through continued Clean Rivers program monitoring of bacteria concentrations. 5-year progress reports will allow stakeholders and the TCEQ to evaluate results and adapt the plan as needed. Funding for these measures will come from a combination of existing local utility budgets, state and federal grant programs, such as the Clean Water Act Section 319H non-point source grants, USDA and Texas Water Development Board infrastructure programs, and voluntary landowner and local government contributions. Implementation of each measure is contingent on the availability of those resources. OPIC recommends granting approval of this stakeholder-supported science-based plan because it advances the public interest by protecting water quality, public health, and recreational opportunities in a growing region. Thank you.
Thank you, Eli. I'd like to thank staff for all their efforts on this implementation plan. I'd also like to note the extensive stakeholder involvement throughout this water quality planning process and thank everyone who participated in that process for their input and involvement. This is a better plan because of your support. With that, I'm ready to move forward with approval. Colleagues?
I'm ready to move forward too. Thank you for all your work.
Yes, thank you for all your work on this.
Do I have a motion?
I move that we approve the implementation plan for 9 total maximum daily loads for indicator bacteria in the Chocolate Bay watershed of the San Jacinto Brazos Coastal Basin and Bays and Estuaries Basin, as recommended by the Executive Director.
Do I have a second?
Second.
All those in favor say aye.
Aye.
Thank you. The motion passes. Thank y'all. We'll move on to the enforcement docket.
That does take us to our enforcement docket, which are items 5 through 44, and the Executive Director's staff is here to present these matters.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Megan Hamilton of the Enforcement Division, and with me today are Amy Sedemeyer, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 5 through 44. The total assessed administrative penalties are $2,074,420, with $251,272 deferred, $502,693 applied towards supplemental environmental projects, and $1,320,455 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you very much. Mary, do we have anyone signed in on this item, these items?
First of all, I acknowledge that on items 5, 6, 12, 13, 15, 16, 19, and 23, we have individuals who are signed in but indicated that they don't wish to address the commission. And then on 3 other items, we have people signed in to allow enough time for all who wish to be heard during this meeting. The commission limits initial comments from each speaker to 3 minutes, and we'll extend that time if the commission needs further discussion with the speaker. With that, we'll begin with Mr. Gene Chance, who I believe is here on 24. He may be virtual.
Yes, this is Gene Chance. I'm a citizen of Orange, Texas, and I realized that I've mistakenly requested to speak on item 10 when actually it is another item that I need to speak with, and that's item number 24. So I yield my time.
Yes, you can. Oh. Do you have any comments on 24?
Yes, I mean, not really. I agree with the council and all present on item number 24 pertaining to Sienna shipyards. And I believe that probably likely we'll have future opportunities to contribute.
All right, thank you, Mr. Chance. We will move on to Ruben Rania, and I believe he wants to comment on item 26. Mr. Rania?
Yes, ma'am.
We can hear you.
With all the respect, I don't speak and understand English very well.
That's
and
fine.
I need more time to seek a legal attorney. Please, I need more time with all respect.
Thank you, Mr. Rania. Hold 1 second. Gitanjali, Amy, Megan, can you explain the opportunities that Mr. Rania had to advocate for himself on item 26?
Yes, this is Gitanjali out with the litigation division. Item 26 is a default order for municipal solid waste violations that were unauthorized. And in this matter, the enforcement division tried to reach out to Mr. Rania and was unable to contact him. And so the case was referred to the litigation division. The petition was filed in August of 2025, and then again, it was sent certified mail. So our rules require that service of a petition is met if you send it via certified mail. If it comes back unclaimed, you send it again simultaneously, certified and first class. And if it is unclaimed but the first class mail doesn't come back, then we presume service, and that's what we had here. So the second service was sent October 1st, 2025, and then the green card was returned on November 14, 2025 as unclaimed, but the first class did not return. After that, the attorney responded at the number that she had, but it was out of service. That's the only number we had, so we attempted a call on December 22nd, 2025. On January 12th, 2026, called again at the same number. The phone rang, but no answer or voicemail, so we couldn't leave a message. And then we tried once again on January 21st, 2026. We called the number, and it was still not working. And then after that, we mailed the default order, the draft default order. We send out a last chance letter letting them know that they have one last chance to file an answer. And if they don't, that we would be recommending the issuance of a default order. And then we mailed out the agenda on July 24th, 2026, notice of the agenda. So that's what happened here. So there were multiple opportunities.
Mr. Rania, it appears that you had multiple opportunities to advocate for yourself or be informed of what was happening. Did you receive any of that correspondence?
Ma'am, I live in another state, and when my wife called me on last week, saying that we have the one letter, and then when that's when I started to look in help, but I haven't found no one. But I did not. I didn't get no letters before. Only this one letter. Just one letter I found last week, and I'm making looking for help to resolve this matter. I need respectfully. I need time, please.
I hear you, Mr. Rania. Our rules exist for a reason, and I believe that you all satisfied everything you needed to do to contact the Mr. Rania, but I'm willing to hear from my fellow commissioners if they have hesitations about moving forward. Sure. Yep. Let's take about 5 minutes, and we will be back at 10:37. We're in recess. All right, this commission is called back to order. The time is 10:37. Mr. Rania, are you still there?
Yes, ma'am.
I am very sympathetic that you did not receive the multiple attempts of service. I would like to note that you also have one pending enforcement action. Did you know that?
No, ma'am. No, ma'am.
Okay. Well, I'm willing to see what my fellow commissioners would like to do.
I think anytime, we have an enforcement case, we're obviously concerned about, due process. I do think that due process was served here. I think the multiple attempts and, if that is not the gentleman's address of record, he needs to make sure that's updated. If that's not his phone number, he needs to make sure the phone number is updated. He clearly got notice of this hearing today, and now he has actual notice of the pending enforcement matter. So I'm prepared to move forward today.
Commissioner Miller?
I'm prepared to move forward. I would just say, Mr. Rinya, reach out to our staff and give them your updated contact information so that we ensure that you receive all the notices that we're sending to you.
Mr. Rania?
Yes, ma'am.
Someone from the executive director staff will be contacting you to get updated contact information. Thank you.
Yes. Do you need my phone number?
Sounds like they do.
Yeah. Yes. Well,
I think that the chief clerk's office can reach out to Mr. Reyna using the information that they have from his registration here. And I'll ask the chief clerk to reach out to get that information from you, Mr. Reyna.
thank you, sir. We're moving forward. Appreciate your comments, and someone will be in contact with you. I believe we have one more comment on item 20. Mr. Zaffer Aston? Arasti. And you're in person.
Good morning.
Good morning. Welcome to TCEQ. You can begin.
Okay, we are talking about the penalty, right?
I'm sorry?
We are talking about the penalty.
Yes.
Well, we're just wondering why penalty is so high, and we don't even know exactly what went wrong over there.
And you're commenting on item 20?
Yes.
Gitanjali?
Yes. So item 20 is a default order, and it involves a construction site for BMP and deed notice recordation violations that involve a violation of a previous commission order. This petition was filed back in July of 2025. A green card was signed in July 29, 2025, so notice was obtained in this case. And since the notice of the petition, the attorney has been in sustained communication with the respondents. She called right after service of the petition, spoke to Anjum Aratsu about settlement, discussed compliance options, since this is a violation of a prior agreed order, referred them to Small Business and Local Government Assistance, who also reached out to them in September 5th, 2026. And after that, had numerous phone calls and emails with them. It sent options, I think gave them OPIC's number in December 5th, 2025. And they did have issues with the penalty, but we let them know that they needed to file an answer if they felt they could not settle the case. And then they could submit FIP documentation. And we also asked for compliance documentation, which we didn't receive. This all culminated in a meeting that was held in July 24, 2026. Respondents showed up and they spoke to the attorney, and she once again urged that they needed to file an answer if they had issues with the case and could not come to a settlement on this case, and let them know that the deadline to file an answer was August 4th, 2026, and we still do not have an answer in this case.
We hired the company, Alamo Company. We paid $5,000 and asked them to comply with the fan unit, and somehow they never did it. They just took the money and just disappeared. And I have no idea what's happening with the company, and we keep trying to contact them, and they're not responding us. We try to comply the issue. And I talked to the attorney also.
I believe that you've had several opportunities to discuss and file what you needed. Did you not meet with these ladies or an attorney at TCEQ?
No, we did. I talked to I think Jennifer Peltier. And I told her that we try to make the compliance.
Okay. I believe that we have done everything that we need to do to move forward with this. I'm sorry.
So are you requesting the penalty to be reduced? Because why penalty is so high? We request if we can make the penalty reduced.
I can't negotiate penalties at the dais. Gitanjali, do you want to explain?
Well, the penalty is high because it's a violation of a prior agreed order. So in that case, it's appropriate to have a higher penalty since the compliance was not achieved with the first agreed order. Yes, and Jennifer Peltier is the attorney that met with respondents, and she is in the audience today.
Jennifer, are you in? I'm glad you were in the audience today. Jennifer, can you explain your meetings with Mr. Arasti?
Yes. Ooh, that's very loud. Good morning, Chairwoman, Commissioners, General Counsel, Public Interest Counsel. For the record, I'm Jennifer Peltier. Yes, I have met with the respondent. We've also talked on the phone a few times. I have walked them through the penalty policy and explained to them, like Gitanjali had previously mentioned, why the penalty is so high, because it goes back to the previously agreed order.
All right. I think we've done everything that we needed to do with the respondent. Thank you for your comments. I believe we're going to move forward with the item. Thank you for being here.
Okay, moving forward for that means penalty remains same.
We are moving forward as the penalty, well, I don't know yet. I would like to move forward with the penalty as stated by our agreed orders. Any objections?
No objection. No, it looks like this has been initiated over 4 years ago. I mean,
It's a long time. Thank you for your comments. Appreciate it.
Okay.
Jennifer, would you call him after and kind of walk through what has happened?
Yes, I can do that.
Again,
Thank you.
Thank you. Appreciate you. Thank you very much.
Thank you. Thank you.
Thank you.
All right. Do we have anyone else signed in?
No one else signed in.
All right. OPIC?
Good morning again, Chairwoman, Commissioners, General Counsel, and Executive Directors, Attorneys, and staff. My name is Eli Martinez with the Office of Public Interest Counsel for the record. OPIC has reviewed these proposed agreed orders between TCEQ and respondents and does not object to their approval. OPIC appreciates the efforts of the parties to resolve these matters and looks forward to fulfillment of the terms of the agreements in accordance with the schedules set forth therein. We also appreciate the effort undertaken to pursue the default orders on today's agenda. Should the Commission have questions concerning any particular item, OPIC would be happy to consider the matter further.
Thank you. I'd like to thank staff for their work on these enforcement items. Hearing everything that you all do to make sure that communication with respondents, it's thorough. It's there for a reason, and you all are very good at giving people multiple chances to discuss these penalties and fines. So thank you for that. Our enforcement philosophy at TCEQ is compliance first. Our goal is not simply to assess penalties. We want to achieve compliance as quickly as possible, prevent reoccurrence, and produce lasting environmental results. We measure effective enforcement not only by the penalties we assess, but also by the environmental impact a community will achieve. The SEPS option does exactly that, so I'm excited to see that we have almost $500,000 in SEPS today on the agenda. And I know Commissioner Gonzalez is a big fan of the SEPS. I'm ready to move forward with adoption. Colleagues?
Same, as always, I appreciate the hard work that all the enforcement coordinators and leaders within the division are doing. And as the chair noted, we have a number of great SEPs on today's agenda, so I really encourage everyone to participate in that program if they are finding themselves in an enforcement situation. Thank you.
I'm in agreement and ready to move forward.
Great. I move that we adopt items 5 through 44 as recommended today by the Executive Director. Do I have a second?
Second.
All those in favor say aye.
Aye.
Aye. Thank you very much. Thank you, ladies. Appreciate you. We'll move on to 45 and 46, rules matters.
Item number 45 is the consideration of the publication of and hearing on proposed amendments to 30 Texas Administrative Code, Chapter 205, General Permits for Waste Discharges to implement Senate Bill 1302, 89th Legislature, and continue to implement House Bill 2694 from the 82nd Legislature. The Executive Director's staff is here to present this item.
Good morning.
Good morning again, Madam Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, again, I am Shannon Gibson with the Water Quality Division, and with me today is Anthony Tatu with the Environmental Law Division. The proposed rulemaking before you would implement changes to the Texas Water Code made by Senate Bill 1302 from the 89th regular legislative session and continue to implement changes made from House Bill 2694 from the 82nd regular legislative session. Senate Bill 1302 amended Section 26.040 of the Water Code to state that if an authorization under a general permit is denied or suspended by the Commission due to an unsatisfactory compliance history rating on or after September 1st, 2025, then the entity may not be eligible to discharge under a general permit until the Executive Director actively authorizes the discharge to use the general permit. It further amended this section to prohibit the Executive Director from using an automated process to approve or authorize an application under a general permit following the denial or suspension of the general permit authorization ordered on or after September 1st, 2025, due to an unsatisfactory compliance history rating. House Bill 2694 amended Section 26.040 of the Water Code to clarify that the Commission, after hearing, shall deny or suspend a discharger's authority to discharge under a general permit if the discharger's compliance history rating is unsatisfactory. While in practice, the executive director has implemented the statutory changes as required by House Bill 2694, this is the first opportunity that the Administrative Code, Chapter 205, has been open since the 82nd legislative session to incorporate these changes into rule. This rulemaking proposes to amend Section 205.4 of the Administrative Code to clarify that the Executive Director shall deny authorization to discharge under an existing authorization if the discharger has an unsatisfactory compliance history rating, that once a discharger authorized under a general permit has been denied an authorization, the discharger is not eligible for a general permit again until the ED actively authorizes the discharge to use the general permit. And finally, that an automated process may not be used to approve an application under a general permit following the denial or suspension of an authorization. A hybrid in-person and virtual public hearing on this proposal is scheduled for September 28, 2026 in Austin, Texas. Staff respectfully recommend approval to publish our notice of hearing and proposed rulemaking on Chapter 205, Section 205.4. In addition, staff requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you again for your time, and we are here to answer any questions you may have.
Thank you very much. Mary, has anyone signed in on this item?
No one has signed in on this.
All right, OPIC?
Good morning, Chairwoman, Commissioners, General Counsel, and Executive Directors, attorneys, and staff. For the record, I'm Michael McCarthy on behalf of OPIC. OPIC has reviewed this proposal for rulemaking and respectfully recommends publication. The rulemaking is primarily legislative implementation and serves the public interest by ensuring additional agency review of entities with poor compliance histories before they are again authorized to discharge under a general permit. Thank you, and I'm available for any questions.
Thank you very much. First, I'd like to thank staff for their work on this project and OPIC for their review. As staff indicated, these amendments to Texas Water Code Chapter 26 are proposed to fully implement SB 1302 and a portion of HB 2694. Specifically, the proposed amendments revise Section 205.4 to clarify that 1, the ED shall deny authorization to discharge under an existing permit if the discharger has an unsatisfactory compliance history rating. 2, once a discharger authorized under a general permit has been denied an authorization, the discharger is not eligible for a general permit again until the ED actively authorizes the discharger to use the general permit. And 3, an automated process cannot be used to approve an application under a general permit following the denial or suspension of an authorization. I've reviewed the proposal and I'm ready to publish it and see what the public has to offer. Colleagues?
I agree, and then when I appreciate staff staying true to the legislative directive. It looks like a pretty straightforward implementation. So, thank you.
I'm in agreement.
Wonderful. Do I have a motion?
I move that we approve the publication of and hearing on the proposed amendments to 30 Texas Administrative Code, Chapter 205, as recommended by the Executive Director.
Do I have a second?
I second.
All those in favor say aye.
Aye.
Thank you. The motion passes. Thank you. We'll move on to item 46.
Item 46 is the consideration for publication of and hearing on proposed amendments to 30 Texas Administrative Code, Chapters 305 and 335, the proposed repeal of Section 335.181 and 335.251, and the proposed new Section 335.251. The Executive Director staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Jarita Sepulvedo with the Waste Permits Division. With me are Shri Venkat, also with the Waste Permits Division, Mark Stobner with the Fiscal Control Division, and Thomas Hopkins with the Environmental Law Division. The proposed rulemaking would add revisions made to federal regulations into state regulations and implement program-initiated financial capability requirement revisions, updates, corrections, and repeals within state rules by amending rules in 30 TAC Chapter 305 Consolidated Permits and Chapter 335 Industrial Solid Waste and Municipal Hazardous Waste. A hybrid public hearing will be offered on this proposal in Austin and online on September 22, 2026. Staff respectfully recommends approval to propose the publication of and hearing on 30 TAC Chapter 305 and Chapter 335. Staff also respectfully requests permission to make non-substantive revisions to comply with Texas Registry requirements. Thank you. We are available to answer any questions.
Thank you very much. Mary, is anyone signed in on this item?
No one is signed in on this one.
Right, we'll hear from OPIC.
Good morning again, Chairwoman, Commissioners, General Counsel, and Executive Directors, Attorneys, and staff. My name is Eli Martinez with the Office of Public Interest Counsel. For the record, OPIC has reviewed the proposed rulemaking and supports publication. This package accomplishes two primary objectives that serve the public interest. First, it incorporates necessary revisions to the Federal Resource Recovery and Conservation and Recovery Act regulations so that Texas can maintain and strengthen its authorized hazardous waste program. Second, it makes targeted program-initiated improvements to state rules governing financial capability demonstrations and corrects outdated or inconsistent language. The federal updates address 4 RCRA clusters. Checklist 200 completes early adoption of the zinc fertilizer exclusion so that secondary materials used to manufacture zinc fertilizers can be properly excluded when the specified conditions are met. Checklist 243 updates flashpoint test methods to current ASTM standards and provides alternatives to mercury thermometers. Checklist 244, mandatory for continued authorization, conforms import-export notice and movement document requirements to recent Canadian regulatory changes. Checklist 245 authorizes use of EPA Method 23 for dioxin, furan, PAH, and PCB emissions testing. Together, these changes keep Texas rules equivalent to the federal program, reduce compliance friction for multi-state operators, and give the regulated community clearer, more current analytical tools. On the Texas-only side, the proposal revises the financial capability demonstration under Texas Health and Safety Code, Section 361085. Under current rule, an applicant cannot rely on existing financial assurance instruments to show financial capability for permit amendments, renewals, or transfers. The proposed change allows the reliance for existing permittees while still requiring a full capability demonstration for new facilities. The result is a more efficient process that reduces unnecessary duplication of financial documentation without diminishing the statutory requirement that an applicant demonstrate adequate resources to construct, operate, and close a hazardous waste facility. Additional clarifying and housekeeping amendments improve consistency, reducing paper application copies while requiring an electronic duplicate, refining Class 3 modification public meeting timing, restoring inadvertently omitted exception reporting language, removing obsolete technology and elementary neutralization provisions, and aligning certain maximum contaminant and action levels with the current federal standards. A stakeholder meeting was held in May of 2025, and only 2 comments were received. No controversial issues or significant fiscal impacts on the public have been identified. The changes primarily affect the regulated community and agency workload in ways that should enhance permitting efficiency. For these reasons, preservation of RCRA authorization, greater clarity and flexibility in technical standards, and a more practical financial capability process that still protects the public, OPIC recommends that the Commission approve the proposal for publication and public hearing. Thank you. I'm available for any questions.
Thank you, Eli. I appreciate the thorough analysis. I'd like to thank staff for their hard work on this rulemaking project. The proposed rulemaking updates 30 Texas Administrative Code Chapters 305 and 335 to incorporate EPA's amendments to the Federal Resource Conservation and Recovery Act, or RCRA. The mandatory RCRA amendments ensure that Texas meets the minimum standards of the Federal Hazardous Waste Program to maintain its RCRA authorization, and the optional amendments ensure equivalency with the federal rules and provide regulatory consistency for entities operating in multiple states. Additionally, this rulemaking project proposes program-initiated changes to these chapters, including revising the hazardous waste program's financial capability requirements, and other updates, corrections, and repeals to improve the accuracy and clarity of TCEQ rules and to increase programmatic efficiency. I'm ready to move forward and welcome public comment on this item. Colleagues, thoughts?
I agree, and I really appreciate that we have these program-initiated revisions to the program. It's going to streamline the permitting process and reduce confusion for applicants. And I always appreciate it when staff takes the initiative to find efficiencies and ways that our agency can improve within the bounds of our authority. So I look forward to public comment on this rulemaking.
Well said. Commissioner Miller?
So I was going to say, well said, Commissioner Gonzalez. I'm ready to move forward.
Thank you. Do I have a motion?
I move that we approve the publication of and hearing on proposed amendments to 30 Texas Administrative Code, Chapters 305 and 335, the proposed repeal of Sections 335.181 and 335.251, and proposed new Section 335.251 as recommended by the Executive Director.
Do I have a second?
Second.
All those in favor say aye.
Aye.
Thank you. The motion passes. Thank y'all very much.
Okay, that does bring us to our public comment session. The Commission will receive comments from the public on any matters within the jurisdiction of the TCEQ in accordance with Texas Water Code Section 5.112, except for pending permit matters or other contested cases, such as specific enforcement cases, which are subject to the ex parte prohibition found in the Government Code Section 2001-061. In the interest of time, speakers will be limited to 3 minutes each, with a total time for public comment limited to 1 hour. Please note that the Commission's discussion of subjects for which public notice has not been given is limited to statements of specific factual responses and recitation of existing policy. We have 2 people signed in, and we'll begin with Catherine Guerra, who is, I believe, virtual today.
Good morning, Commissioners. I'm Catherine Guerra with Public Citizens Texas Office. I serve as Director of the TCEQ Watchdog Campaign. I'm speaking today about the TCEQ's upcoming annual performance goals and the agency's draft FY 27-28 legislative appropriations request. Public Citizen has said it before, and we will reiterate it today. This agency cannot continue to permit pollution without enforcement and without consideration of the environmental and public health harms experienced by Texans. TCEQ did not publicly post its A-Best quarterly performance reports for Q2 or Q3 of 2026 on its website, but based on the TCEQ's 2025 annual performance report, we've identified that TCEQ is quite proficient at issuing permits, but the agency fails to enforce compliance of those permits. That report says that in FY25, TCEQ met 112% of its goal to issue air permits, issuing 7,855 air quality authorizations. But in the key performance measure to determine the percent of Texans living where the air meets federal air quality standards, TCEQ's target was just 43%. It achieved 42% of that goal. But why is the bar so low? What about the other 58% of Texans who want to breathe clean air? Is this agency not responsible for upholding the air quality standards for them too? In 2021, the agency's target for that goal was 100%. Over the past decade, the agency has not achieved greater than 45% of its goal for clean air. So instead of continuing to work towards actions that would help the agency meet that goal for Texans, TCEQ simply lowered the bar for itself. Similarly, TCEQ failed to meet another key performance measure regarding percent of stationary and mobile source pollution reductions in ozone non-attainment areas. Instead, air pollution increased. The TCEQ issued approximately 760 water quality permits in FY25. That was about 90% of its target for that goal. TCEQ has a key performance measure to determine the percent of Texas classified surface waters meeting or exceeding water quality standards. TCEQ met 54% of that goal, of the target. So what about the other 46% of Texas surface waters? TCEQ similarly failed to meet its goal to reduce pollution from permitted wastewater facilities discharging into waters of the state. Instead, wastewater pollution increased. Public Citizen has a long history of advocating for funding for TCEQ with the legislature and a history of earning that funding for staff salaries, for mobile air quality monitoring, for Rider 7 funds. The TCEQ's need for enforcement resources must be reflected in its legislative appropriations request, and TCEQ has posted the agenda for that work session on Monday, but not the draft documents to be considered for the public to review. To be clear, Public Citizen recognizes that committed career TCEQ staff have a very difficult job and that the direction of the agency is largely beyond their control. The problem is one only leadership can address, and it can be remedied by ensuring that enforcement staff and regional investigators have the funding necessary to carry out the agency's mission and just keep up with the agency's permitting functions. And lastly, just as a practical example, in the case against Mr. Reina Carvajal, it appears TCEQ issued the NOE in 22, but waited 3 years to mail the certification. So perhaps some additional funding would also shorten that gap and address similar issues with unresponsive respondents and default orders. Thank you.
Mary, who else has signed it?
And we have Adrian Shelley, who is there in person.
Good morning, Commissioners. Adrian Shelley, Texas Director of Public Citizen. Appreciate the opportunity to speak this morning, and I'm speaking also on behalf of our 30,000 members and supporters across Texas. I want to address yesterday, there were 2 cancellations of public meetings, one in San Antonio and one in the Panhandle. I want to urge the Commission to articulate a reason for those cancellations. It's difficult for members of the public to, arrange to be at these meetings. It's an investment in time and resources. People reach out to their communities, they prepare comments, and it's tough when things get canceled and rescheduled. So I encourage you to give a reason for those cancellations. When we say that there's a lack of public trust in the agency, we're not doing so as an attack on staff. We're doing so because it's a reflection of what we see and hear in public spaces. In July 22nd, the Environmental Protection Agency held a virtual public meeting on the minor NSR public participation rulemaking. There were a little bit more than 100 folks that spoke. This was a nationwide hearing. 45 people were from Texas and spoke about the TCEQ, and they weren't complimentary. They were concerned about erosions of public participation and a lack of meaningful public engagement, and they're concerned that the EPA rule is going to make that problem worse. The 2 cancellations happen to be air permits for data centers. Obviously, data centers are on a lot of people's minds these days. The ED was asked about it several times in Natural Resources yesterday. Some of the largest permits, in fact, the largest permit in the country was issued in Amarillo, the Fermi permit, earlier this year. But in many cases, we think facilities are probably getting minor source permits when they ought to be getting major source permits. There is clear statutory guidance on source aggregation. There are clearly applied criteria. If there is common control, if the SIC codes are the same, the first 2 digits, and if the facilities are operationally interdependent, that is to be counted as a single facility. We think that the backup power generators and the co-located power plants at a typical data center meet this criteria for source aggregation. But in many cases, these things are permitted separately as minor sources. There's also the problem of the phased approach of data centers. They will get a minor source permit on a portion of a facility that is clearly intended to become larger. Opinions may differ about how this is applied, but what we would suggest is that the agency clearly discuss and apply those source aggregation criteria in these permits, specifically with data centers. People are asking about them. Lawmakers are asking them about them. They are preparing for the legislative session and questioning whether the current regulatory approach is protecting Texans. So we want to encourage you to be transparent, and that will help to build confidence. Thank you very much.
Thank you. Mary, do we have anyone else here that wishes to address the board?
We do not. That concludes the registrants.
All right. With that, the commission will not meet in closed session today. So Do you need to read your things? So there being no further business before the commission, this commission agenda stands adjourned. The time is 11:11. That's a lucky number, y'all.